Hello, everyone. We are here today to discuss overcrowding, wellness, and prisoners' rights. I'm Ben Georgia.
I'm Angel Bridges.
I'm Brady Spores.
I'm Morgan Devine.
I'm Tori.
I'm Tyler Munoz.
Those who commit crimes need to face the consequences, and we are not going to argue against this fact. However, the overcrowding of prisons is a vast problem and has severe and lasting impacts on those who live within them. There are about 2.1 million people incarcerated in local, state, and federal institutions, which does not include youth facilities, territorial prisons, immigration detention centers, and other facilities that are used to detain people. Not only are a lot of people affected by overcrowding in prisons and the health hazards that stem from it, but there are also many suits that have been filed regarding physical health and mental health care within prison. The case of Brown v. Plata argued that inmates were not receiving sufficient medical care in California prisons, while Coleman v. Schwarzenegger addressed the lack of mental health care that was available to inmates in the same places. It was determined that these deficits were due primarily to facility overcrowding. Furthermore, the Supreme Court has ruled that prisons need to consider the health care of their inmates and cannot just turn a blind eye to their suffering, for it would be a violation of the Eighth Amendment, which was created to prevent the cruel or unusual punishment of inmates. Prisons throughout the entire country have increased in incarceration rate significantly. Further details and statistics regarding these harsh circumstances will be touched on later in the presentation. What we have here is a pie chart that depicts the 2.1 million people incarcerated in the United States. As you can see by the large sea green portion, we have 1.3 million people locked up in state prisons. The orange region shows that we have over 500,000 locked up in local jails. The smaller yellow region shows that there are 221,000 in federal prisons and jails. Finally, we have the smaller portion on the right-hand side that is mostly dominated by the amount of people imprisoned in immigration detention centers and in youth prisons. The small labels throughout the chart explain how many of each respective portion are imprisoned for a specific reason. For example, the bottommost portion of the state's prison section is made up of over 700,000 violent crimes, including 179,000 murder, 172,000 robbery, 163,000 rape and or sexual assault, 130,000 assault, and 18,000 manslaughter cases. Another category includes the 198,000 people incarcerated for drug-related crimes such as possession and distribution. These are just in state prisons. Reviewing these staggering numbers, it is clear that prison crowding needs to be addressed. Tori will begin by reviewing related cases.
In most areas regarding individuals' rights, there's a case that sets the precedent. For prisoners' rights, that was Estelle v. Gamble. As Brady mentioned, in 1976, the Supreme Court ruled that inadequate health care for inmates constituted cruel and unusual punishment, a violation of the Eighth Amendment of the U.S. Constitution. This ruling further stated that a violation of the Eighth Amendment didn't just result from purposeful mistreatment of an individual, but from deliberate indifference to medical needs. This meant that a prison could not ignore the needs of its inmates. It had a legal responsibility to provide adequate health care. This ruling opened the door for other suits in the years to come, up to the present day. Two in particular that we're looking at both concern the California prison system. Brown v. Plata was originally filed in 2001, citing inadequate medical care in California-run correctional institutions. Coleman v. Schwarzenegger was first filed in 1990, and it focused on medical health care in the same places. Both of these cases were originally filed separately, but due to a lack of results, they were reopened under a 3-judge court and the Prison Litigation Reform Act, or the PLRA. This was a federal law enacted in 1996. The PLRA created a set of standards to provide relief in cases about prison conditions. In particular, it had a specific set of requirements in order to call for a prison release order. This needed to find that less intrusive solutions had been tried, so that the cases had been settled under other means, but it was ineffective. It also required that a 3-judge court would be established to consider a prison release order. And finally, it required that court determined that crowding was the primary source of violations and that nothing else could remedy this. So even though neither Brown v. Plata or Coleman v. Schwarzenegger were originally about overcrowding, the court decreed that it was the primary cause of these violations and thus issued a prison release order to reduce California prisons to 137.5% of their design occupancy. Previously, it had been at 190%. Unfortunately, there is not information about results of this order, which should have been completed by 2011. This could mean that it was ineffective, followed out, but didn't improve mental and medical health care. Or it could mean that the order wasn't held to be accountable and that it wasn't followed through. Either way, changes are necessary. Another attempt to fix prison overcrowding is reducing recidivism via therapy and schooling programs. The RAND Corporation has conducted studies that have shown that participation in these types of programs caused a lower likelihood of recidivism, but the studies could not conclude what type of programs were most helpful. Finally, the Bureau of Prisons has used cognitive behavioral therapy, or CBT, to reform inmates by improving social skills, self-efficacy, impulse control, and more. However, there is currently a lack of resources to fully utilize CBT for large prison populations. Tyler will now discuss some statistics regarding prison overcrowding.
There have been multiple statistics that we have found to help solidify that overcrowding in health is truly a problem in the prison system. One statistic that really stuck out to us was that the average occupancy level in the United States prison system is 103%. Also, according to a study done by the Bureau of Justice, about half the state's prison systems were operating at 90% or more of capacity. In a 2001 study done from the Justice Department, it shows that 20% of United States prisons do not utilize mental health screening to determine necessary treatments for inmates. So about 1/5 of the prisons do not determine the proper care that is needed for the inmates when they enter into the prison system. Christian Henrichsen did a study in 2012 across 40 states to determine the cost that inmates cost taxpayers per year. The study concluded that inmates cost taxpayers a total of $38.8 billion a year. When broken down across the 40 states, this number comes out to $31,166 per inmate that taxpayers are paying for. It was later found that only 40 states wanted to participate in this study, so that's why we only got the data across the 40 states. So the averages of cost per inmates range as high as $60,000 a year down to as low as $14,000 a year. This map was taken by the U.S. Bureau of Justice Statistics, and it was a study done in 2017 across the incarceration rates state by state. All rates were taken in per 100,000 of the population. Per observation of the map, you can see that a lot of the concentration of the overcrowding is in the southern states. And the southern states range from 486, which is as Texas is at 486, Arkansas is at 598, Oklahoma is at 704, and Louisiana topping us out with 719. The average for the nation is 440 per 100,000. With that national average in mind, we can see that the southern states are above the national average for the people incarcerated per 100,000. And now Morgan for relevance to our legislation.
As with any change, you have to look into the past and current times. Previously, Tori mentioned some past solutions people have thought of to reduce overcrowding in prisons. Now we look into current legislation to what can change to reduce this problem. The first legislation looked into was the First Step Act, which was enacted into law in 2018. This was created to improve criminal justice outcomes as well as to reduce the size of the federal prison population. The First Step Act created more responsibilities for a number of people to create a safe environment. A few examples of these responsibilities are: a risk and needs assessment must be developed by the Attorney General. Training needs to be taught to correctional officers and BOP, Bureau of Prison employees, on how to de-escalate encounters and how to identify and appropriately respond to incidents that involve people with mental illness or other cognitive deficits. It also allows federal inmates to obtain good time credit for every year they are sentenced and reformed minimum sentencing for some drug offenses. It also allows courts to sentence low-level, nonviolent drug offenders with minor criminal histories to less than the required mandatory minimum for an offense. While these are all good ideas, more can and needs to be done. For example, we could expand it to state and not only federal prisons, and exploring more of the mandatory minimum sentences that are more proportional to the crime that was committed. The second legislation we looked into hasn't actually been passed yet. The Sentencing and Correction Act, which was introduced in 2017, it explores restoring proportional sentences and introducing more programs and risk assessment systems. As this hasn't passed yet, we do not know whether this would improve or make things worse, but it is important to look into everything that is out there to completely understand the problem of overcrowding within prisons. By looking at these legislations and our research, we found that many similarities, such as reducing mandatory minimum sentences, introducing more programs, and more interest into the needs of inmates, we found our innovation through these ideas, which Ben will explain in more detail.
There are standards of care and treatment in prisons, which are stated by the American Bar Association. They state that inmates should be prepared to live law-abiding lives when they leave prison. A lack of resources should not excuse treatment or violate prisoners' constitutional or statutory rights. And accommodations for medicine, treatments, and needs should not go unnoticed and should be taken care of in a timely, responsible manner. And even though the American Bar Association states this, there are problems with providing these standards in overcrowded prisons. As stated by Tyler before, many prisons in the United States average 103% occupancy, so this is a very large problem. We would like to propose legislation that cracks down on regulation of services and calls for a mandatory cleanup of prisons. Cleanup meaning lesser punishment for lesser crimes, those like drug, theft, and misdemeanors. For example, drug charges make up as much as 380,000 convictions in jails. This would in turn free up a significant amount of space in jails, meaning we could focus more on recidivation. Then things like community service, treatment, and employment assistance would be required to acclimate ex-inmates back into society. These programs would build better community members that are able to feel comfortable and better fit to positively add to society and propel them back into normal life. In tandem with lowering the amount of overcrowding, this would also save taxpayers money. Across 40 states, prisons cost taxpayers $38.8 billion. In addition, across the 40 states, it costs an average of $31,000 per inmate per year. This number clearly shows that a substantial amount is being taken from individuals and put towards the prison system. Lowering the number of inmates would ultimately lower the operating costs of prisons and in return would save taxpayers money in the long run. This solution would take a long time, however, and it would need to pass multiple levels of government along with going through a lengthy conception and revision period. For this to pass all the levels of government, it would be assumed that officials would not follow the lock them up and throw away the key mentality, which is pretty self-explanatory. They would need to see the benefits for the economy, the inmates themselves, and their rehabilitation into society over the idea that they will only cause more crime, which can be a hard change in mindset to have. Other potential problems that add to the long timeline are it could potentially never be passed if lawmakers do not widen their view. It would require a lot of hard work, feedback, and understanding society to word and explain this bill. and there is no linear timeline for this bill to follow. However, if things do end up going to plan and the bill passes, it would be enforceable by government agencies, making it sustainable. Over time, we would hope to see the benefits more and more in society. We would see lower operating costs, which would save taxpayers money that can be used to assist other areas of need. Ex-inmates would be properly reintegrated into society, making both the economy, themselves, and their environment better off. It would give them a sense of purpose, potentially deterring them from ending up behind bars again. On-site healthcare workers and providers would be under less stress and would be able to provide more adequate healthcare to those left. Improving the lives of inmates would also have its benefits. This could help combat mental illness or other health-related issues that need tentative caring too. All these things combined will point inmate health, overcrowding, and recidivation in a new direction that will change the way we view these things forever. Next up, Angel will be talking about considerations and what you can do to help.
Thanks, Ben. So we have 4 major considerations following our applied innovation given the current global pandemic. First, we consider pre-existing efforts to release inmates convicted of drug crimes. Technically, that is not innovative in the way that there are efforts from other activists and legislators in the world before us, and we are in a way building upon their backs to make contributions to potentially an ironclad prisoners' rights act in the future. Second, we want to consider states' rights versus federal rights. We acknowledge that states' rights and ownership over prisons and inmates are often predetermined in cases, and attempting to change the course of local and large government can add many roadblocks to our efforts as far as getting legislation amended quickly and with enough support. Third, we consider releasing inmates convicted of drug crimes in practice. Luckily for us, we get to see this play out in front of us. With the coronavirus, there are efforts all across the nation to relieve prisons and prison staff. In Baltimore, Maryland, as of March 18th, 2020, they've released prisoners for drug offenses, trespassing, and traffic offenses, along with other minor crimes. Some states have been practicing releasing inmates based on the nature of their conviction as well as good behavior, with the intention of lowering the number of inmates so that they can have adequate medical care. In Wisconsin, the Department of Corrections released 1,000 prisoners held in jail on probation or parole detainers, which is pretty much a parole violation as of April 2nd. Upon release, many individuals will still have to follow the probation mandates of looking for work, reporting to treatment, and passing drug tests. Given the uncertainty of the world and lacking availability of resources, there is a possibility for a more intense struggle with recidivism for newly released inmates, and perhaps cause a conundrum within our innovation. Finally, resources and housing available for inmates post-incarceration. I currently work at a sober living facility for women where they are required, despite stay-at-home orders and recommendations of social distancing, to receive 15 hours of drug abuse treatment per week, be making a quality effort to look for work, and go to therapy, among many other things. Many of these women have been turned away and left alone without things to do, thus relapsing and immediately being sent back to jail at higher rates than the time before the pandemic. This is evidence that there is no single perfect system, and there are many more parts to having fair law than changing legislation. These considerations are not to say that our innovation does not have great potential. Rather, they say we intend to acknowledge that any large-scale problem solving has room for improvements and the ability to address any shortcomings that may be relevant. The prison system is so vast and complicated that it will take many revisions and a lot of thoughtfulness to execute and implement a system that works for people. Our final call to action to you is to take advantage of your ability to self-advocate and advocate for others by reaching out to your local representatives and making sure your voice is heard, as well as exercising your right to vote in local, state, and federal elections. Thank you for taking the time to listen to our stake in solving the prison overcrowding crisis, and in turn benefiting the health of countless communities and maybe, in turn, the world. Stay safe. Thank you.